As I had mentioned earlier, the KSA Limelight series has talked about creating ordinances, rules, and regulations. Now we want to talk about how we actually enforce those ordinances and why it's so important as we move through the process. There are a few key things that you really want to look at in your ordinances to make sure that they're enforceable. We want to make sure that the ordinances, rules, regulations are worded correctly. We want to be specific and clear enough to follow. However, whenever possible, we want to make sure we reference manuals or permit language. This is because ordinances, rules, and regulations typically have to go through council approval, where manuals and permit languages just go through a general review process and update. Are your ordinances updated? How long has it been since you've reviewed your ordinances? Then can you enforce that actual ordinance? Do you have additional language where you can create civil citations, maybe a lien on a property, or are they just empty threats? Do you have to go to court action? Is it criminal actions? Those are some of the things that we're going to be reviewing. Do you have a citation officer? Somebody who can actually authorize to send civil citations and penalties through that ordinance. That could be a separate person through your facility, or you can use something like your code enforcement officers who already have that process in place. As I had mentioned, you really want to look at who can enforce your ordinances. Informal notices and notices violation can be sent by any authorized person in your MS4. That could be your inspector, that could be the engineer of record and throughout the city or the municipality. However, it takes a certain person to be a civil citation and penalty officer. This is key when you're creating your ordinances or doing your escalating enforcement. We want to be able to have that opportunity to escalate the enforcement process through the entire city, not having to have to go to court action or criminal action. None of us want to go to court. But as I had mentioned earlier, fines and money talk when we are having contractors that don't want to abide by the rules and regulations. As you can see, KRS 83A.087 gives the cities authority to create citation officers. Within the city of Lexington, we have a specific section that references our citation officers and which particular ordinances that they can enforce. However, as a small city, you may not have to get that detailed. I highly encourage you that go back and really review your rules and regulations to make sure that you have this authority. Maybe you don't have that specifically. Maybe you can look at it through your enforcement officer. They may already have that process in place. Now that we've talked about who can enforce our ordinances, I want to switch to how to build an enforceable case. This enforceable case is part of your escalating regulations that is required through your stormwater permit. So we're going to start with the case initiation. That can occur in several different ways. It could be your inspector out doing their required inspections. It could be a hotline, a citizen complaint coming into you directly, or maybe through a council member. That case initiation needs to be recorded and followed up on. Building an enforceable case really starts from the beginning. If you have a violation that's been called in and not from an inspector in the field, you want to make sure that you have some of your pre-inspection checklist. What is the alleged violation? What documentation should you take with you? Are you taking your list discharge form? Or are you taking your erosion sediment form? Do you have additional departments that you should contact in case that they should be involved? Are you the only investigator or inspector, or are there others in town? Where is the violation occurring? Private property, public property? Should you make sure that you print out those maps? These are all basic inspection pre-checklist. We just want to make sure enforceable cases start from the beginning. We had talked earlier how documentation was so important. While building an enforceable case, documentation is key. So during your site inspection, you really want to make sure that you note, is there a violation occurring? What is the severity? What specific ordinances were violated? Then it goes down to who owns the property versus the responsible party. Could be the contractor not following their permit, or is it an owner doing an illicit discharge activity? Documentation is key. We want to make sure we have those photos, date and time stamped, any communications with the owner or the contractor on site, and our inspection log. Is that your form that you have filled out, or is it a field book? All of those are admissible as we do our enforceable case and escalating enforcement. Once you've completed your site inspections, you need to follow your enforcement response plan. We talked about how important this is in the previous section, that way everything is consistent across the board between inspectors if we want to complete an informal notice, a notice of violation, or a civil citation. Just a quick reminder, your informal notice is your emails, phone calls, and on-site meetings. Don't forget that follow-up email to show that you have attempted to communicate with the violator. If it's a more formal written notice in the form of a notice of violation, then of course we always have the civil citation and penalty options through our civil citation officers. When you're creating an enforceable case and you're sending your notices of violation, we had already talked about the importance of making sure the name of the violator, address of violation, date of the violation observed, etc. As we go through, there's a couple of key notes I want to really make sure that we address. Do you have the right address of the responsible party? In several cases here in the city of Lexington, we have had our notices of violation returned, therefore have had to start the whole process over again. Although you may say, well, I emailed it to them and they accepted that email, email is not admissible in the court of law. So therefore, if you really want to double check your addresses, check maybe the permit that they are filed under. The Secretary of State also has a business listing and search. Google is always an option, or your local revenue office. An additional area that you really want to make sure is correct is, did you check the correct ordinance? You have to make sure that the correct ordinances are written down, or that notice of violation is not valid. Then the list of the corrective actions needed. Be specific. Things like fix construction entrance or correct silt fence erosion sediment control areas. You cannot tell them how to fix it, but you can tell them what needs to be fixed. As we continue through the enforceable case process, it may seem a little tedious. Yes, we know we have an inspection. Yes, we know we have to do our notices. Then once we have, say, a time period that we need to do our follow-up inspections, we know we need to document all of our inspections, continue to document our non-compliance areas. Make sure that you have those photos with time and date stamps. Maps are a great thing to mark up if you have large sites, because sometimes those photos are very difficult to tell where you took them. Then document the compliant areas. So did they fix some of them but not all? We want to make sure that we have a running history of what that site looks like. We had talked about documenting any type of communications and then following up with additional notices if there are still violations present. Although again, this may seem like a very tedious task, building a building, you start with a footer system. You don't just slap up walls on a bare piece of earth and hope that they stay there. We want to make sure that it is a strong foundation as we move forward, because you never know where these cases may end up. Here in the city of Lexington, we actually have a completely separate civil citation and penalty department. We are large enough to do that, but it also helps do the checks and balances. If you are an inspector and you get very frustrated with the contractor, like we all have been there, we want to make sure that the case that we are enforcing is fair and equitable throughout the entire process. So here we do what's called refer to enforcement, that civil citation officer does a case initiation and review to make sure that all of the documentation is there, the communication is correct with the violator, we have the proper notices that have been given, We even look down to make sure that the addresses are correct, that the correct ordinances are checked, that the enforcement response plan has been followed. Then the civil citation officer may do a site inspection with the original inspector to make sure that we understand what all of the concerns are. We then send out a civil citation and penalty, do a follow-up inspection, and repeat as needed. I want to go through a little bit more in depth about our civil citation and penalty process. This is a form we call enforcement referral. So therefore, when an inspector feels that they have done everything they can do to try and gain compliance, it moves up to our civil citation officer. This really helps gather all of that information and the inspector be able to compile all of the information to clearly show that process moving forward. Remember, if it's not documented, it didn't happen. The civil citation officer will then start a case initiation and review. We'll make sure that we go through all of that information. Is the correct responsible party notices on the NOV? Do we have a correct address? Do the inspection match the NOVs? Do those photos match the inspections? Remember, time, date, stamp. Are the corrective actions matching what they're requesting? The appropriate communication with the violator and documentation of the communication key throughout the process. An email chain is always the best way to show that, even though it's not specifically admissible in the court of law, it does show that the inspector has attempted or has continued communication with a violator. Once our civil citation officers have determined that the enforcement documentation referral packet is accurate, everything is needed to move to the next steps, we follow our own enforcement response plan flowchart that you can see here. The next steps is to determine the actual fine or penalty structures, and we'll be working on that in the next slides. Here in Lexington, we actually have a couple of different types of penalty structures. These should be spelled out within your ordinance of how that is determined. Here you can see one type of penalty structure for our roll carts is a very specified first citation, second citation, third citation with value amounts. The secondary kind is a maximum civil citation fine for each violation, not to exceed $15,000. I will continue to work through how we determine exactly what our fine is under the $15,000 mark. As I had mentioned earlier, the City of Lexington has a lot of standardized forms to make sure there's consistency across the board. This is another one. This is our penalty calculation worksheets for any IDDE or post-construction violations. The civil citation officer reviews two different areas to determine what penalty should be assessed: the degree of harm to human or environmental health, and then the deviation from regulatory requirements. We will have these forms up on the KSA Limelight Series website for use for all of your communities. The majority of our civil citation and penalty cases are erosion and sediment control. Because of this and the concerns from various parties, we have decided to create an additional penalty calculation worksheet to really hone down on a point system. As you can see here, we have determined the potential violations, the points associated with that, and then any additional modifiers. Is it their first citation, second citation within a rolling 12-month period, third, etc.? Then if there's additional environmental damage, maybe they're working within a creek or a stream buffer, we assess additional points. We also have lack of paperwork as a standard penalty of $100. Once you determine the number of points that they have based on the previous slide, you come down here and each point equals the monetary fine. This has helped us with any additional appeals that may occur where a contractor doesn't like the fine amount. So when we go through to the Infrastructure Hearing Board, which I will be speaking about shortly, then we can show how we came up with their civil citation and penalty amount and hone down of making it more consistent across the board. Once a civil citation officer has completed the penalty calculation worksheets, they finish their paperwork and with a civil citation and penalty invoice. From there, they overnight mail this paperwork to the violator. We have chosen overnight mail versus a certified mail because certified mail needs to be signed for. Overnight mail you can track. If we do not believe we have an accurate address, we also post this civil citation and penalty at the location of the violation and take a photo. Remember documentation. We email everything to the violator and keep track that information. Remember, email is not submissible in a court of law, but it shows good communication record. The civil citation officer works closely with the original inspector when they're doing the follow-up inspections to make sure that the site is in compliance. If it's not in compliance, we repeat the penalty calculation worksheet and paperwork as necessary. As you can see, we also have to document everything that we do throughout this entire process through either an Excel spreadsheet. We also have folders on our server to document this escalating enforcement process. We also have additional administrative tools here in the city of Lexington when a civil citation and penalty is either not working or is not the correct avenue to go. We have an order to appear where we have the chronic or persistent violators have a face-to-face meeting with the inspector, civil citation officer, and potential director. We also have what's called the compliance schedules. So if you have maybe an illicit discharge or a post-construction control project that will take months to complete, we can put them on a schedule. If they miss a deadline, then we can automatically fine them for missing that deadline. We have a cease and desist or stop work order. This is if you have a environmentally sensitive area, maybe a creek that they're working in. This is not something we use very often. Now, a permit block is something we use consistently. This is when a person has gone through the process of civil citation and penalty, hasn't either had their site in compliance or they have not paid their penalty. Therefore, we can put their company on a permit block and they are not allowed to get any permits within the city of Lexington. That includes HVAC, building permits, electrical, land disturbance permits, etc. An additional tool in the city of Lexington are abatements. Abatements are only completed when a civil citation and penalty process has not worked and the site is not in compliance, but it must pose a public health, safety, welfare concern, be a public nuisance, or have an environmentally harmful impact. If it's determined that abatement process has to be completed and the violator does not pay us back for that abatement process, we can actually put liens on the property. Here in the city of Lexington, we follow the code enforcement procedures as they complete the abatement process on a consistent basis. We're going to get into a little bit of lawyer legalese just so you understand some of the background with civil citations and penalties and why it's so important for things like our ordinances to be correct and we have a civil citation officer and that type of thing. As you can see here, we have a due process, 14th Amendment of the Constitution. No person shall be denied equal protection of the law and that everyone shall be afforded due process of the law. There's two different things when you look at due processes. One is the substantive due process, and that means that you have to have an ordinances in place that are equitable, sustainable, and are legitimate governmental interest. That's why when ordinances are put in place, you have a long process of public hearings and going through the council process, etc. Procedural due process is another extremely important thing when you look at civil citations and penalties. There's two important things. The first is you must give a notice before you are given a penalty for something. That is why we talk about the notice, three types of notices: your informal, your notice of violation, which is your typically your first notice given before you get a civil citation and penalty. So you may be wondering, well, how does that work with things like the speed limit? If somebody breaks the speed limit, how come they get an automatic ticket? That's because their notice is the speed limit signs. And that is their given notice. There's a lot of examples like that where notices can be given through public um, education or a notice on your permit. Typically, though, when we're talking about the stormwater process, it has to go through that notice of violation first before it moves up to the penalty process. The secondary thing is the opportunity to be heard on all civil citations and penalties. And that's where we talk about what we have in place called the Infrastructure Hearing Board, and we're going to go through that process. In order to be in compliance with the procedural due process, we have set up an appeal process. This is outlined within our civil citation and penalties for all violators that state that they have 7 days to appeal that particular civil citation and penalty to a designated person within the municipality. However, if they do not appeal the civil citation within that 7 days, we have it written within the ordinance that they automatically accept that that civil citation and penalty is appropriate. Here in Lexington, our appeal process for all stormwater violations, civil citation, and penalties go through the Infrastructure Hearing Board. You may have something similar through your code enforcement already. The Infrastructure Hearing Board is an administrative hearing, not a court system. Therefore, it is a little bit looser than court, but still has a system in place. We have a hearing officer, which is a voluntary position to overhear the subject matter and the concerns of the appellant. The burden of proof regarding the actual violation is on the MS4 staff or the inspector. This is one of the main reasons documentation from the beginning of the violation is so important. We want to show that escalating enforcement process where we've tried to communicate what needs to be done to be in full compliance. A few key things I do want to point out is you do need the legal representation for the MS4. Typically, that's just your internal lawyer. And if it's a corporation or LLC, they must also have legal representation. This is a KRS statute. Going through an appeal process and the fine details of it could be an entire another presentation. I just wanted to give you a quick overview of what occurs during an infrastructure hearing board or the administrative board. And the first thing is the civil citation officer and inspector provides proof of why they believe that the violation is valid and the penalty is accurate. Then from there, the appellant has the opportunity to rebut and may potentially show evidence of why they don't believe that they are in violation of that ordinance. You can see here a list of dates and specific items that we potentially present during an administrative hearing board. And this is why it's so important to have that correct documentation from the beginning of the process. Not only if you have to go to a civil citation appeal process, but also it shows escalating enforcement for your MS4 permit. Once a hearing officer has heard from both parties, the civil citation officer and inspector, and the appellant, they determine if a violation did actually occur. So that's a yes or no answer. Either way, they need to write down why they chose that answer, yes or no. Then if the answer is yes, a violation did occur, they determine if the penalty was reasonable per the violation. Remember me saying why we wanted to accurately have a penalty calculation worksheet to show why we chose the penalty we did? This is very important when you're trying to talk with a hearing officer of why the penalty was assessed. If they agree that the penalty was accurate, it stays the same. They can reduce the penalty, however, they never can increase it. If the appellant says that they feel that they are still wronged, they have an opportunity to appeal the administrative hearing officer's decision up to district court within 30 days. If this occurs, it typically goes up to your legal department. But this is why you always want to have that documentation and your ducks in a row. Now I'd like to quickly walk you through a case study for erosion sediment control enforcement procedures. This particular inspector did a really great job at outlining his entire escalating enforcement process with all of the correct documentation. As you can see, they did a site inspection on February 24th and found violations. They issued that notice of violation to a construction company with an abatement date of March 9th. On March 2nd, that construction company contacted the inspector stating they were no longer involved in this project. This is all confirmed through an email chain. So the inspector confirmed with engineering that the responsible party had changed for that particular site, and they reissued the notice of violation to the correct party with an abatement date of still March 9th. Because that inspector did not give a time to be completed by March 9th, they waited until March 10th to do a reinspection of that location. Here you can see they've taken pictures of the same location with the same violations and the time date stamp. So they reissued another notice of violation with an abatement date of March 16th. So again, because on their notice of violation, they just stated must be in a compliance by March 16th. They waited till the 17th to go out and do their site inspection. They went out, and here you can see that some of the violations had been corrected, but not appropriately, and there were still significant violations on the site. So they reissued a notice of violation with an abatement date of March 22nd. Then the contractor reached out that same day because he emailed and mailed that notice of violation to the contractor with some questions. However, when the inspector went back out on March 23rd, the site was still out of compliance and actually worse. So at this point, the inspector had decided that they have done enough notices, enough work with the contractor that it needed to continue the escalating enforcement process and go up to a civil citation and penalty process. So the inspector completed the enforcement referral package and sent it up to our civil citation officer. The civil citation officer then went through, reviewed everything, made sure everything was accurate, and determined what their penalty would be based on the penalty calculation worksheet. As you can see here, he has highlighted how he determined coming up with those penalty points. So it was a minor small sediment volume potentially moving into a waterway, roadway, etc. However, this particular contractor, this was their third citation within a rolling 12-month period. So they got a total points of 3. In addition, they had lack of paperwork on their site. So at the time that this particular penalty calculation worksheet was completed, our fine for penalties for paperwork was only $50. We have since then increased it to $100. So their penalty total was $750. After the penalty calculation worksheet was completed, the civil citation officer completed the paperwork for the actual civil citation letter and invoice. They gave the contractor a compliance date of noon on Thursday, March 30th. In this civil citation letter is also the outline of how that contractor could appeal the civil citation and penalty. They had 7 days from the date of the letter. The civil citation officer and inspector were unable to get back out into the site until April 5th, but as you can see, the site is now in compliance. They have changed out their ESC methods, which is completely appropriate, and we have closed out this case. There is a lot when you talk about escalating and enforcement throughout the stormwater process, actually throughout any ordinance processes. This is just a good overview of how your government can move forward, making sure that you have a correct escalating enforcement process, that you document everything, not only to be in compliance with your stormwater permit, but for any potential escalating enforcement cases through civil citations and penalties. If you have any questions, we are going to be taking time at the end of this presentation to answer questions for you. Our next speaker will be Sarah Donaldson talking about internal enforcement.